Hello friends, welcome to Insights Prelims High Yielding series. This is the Polity section. From today onwards, we will, on regular basis, we are going to discuss about the high yielding topics for the 2024 prelims subject wise. Okay. In today's video, we are going to discuss about top 5 polity topics. Of course, this further polity topics also we are going to discuss. In the same way, other subject topics also we are going to discuss, and feel free to give you a review on this kind of initiatives so that I can come up with a better outcome as well. Okay. So first, the following 5 topics we are going to discuss in today's class. Okay. They are number 1, women reservation; second one, CEC and EC appointment process; third one, governor power to decide on bills; fourth one, simultaneous polls; and fifth one, Article 370 and Article 35A. So each and every topic, first the topic I will give an overview, then we will go through the important points regarding that particular topic. So the first topic is regarding the Women Reservation Bill. Recently, Women Reservation Bill was passed as a 106th Constitution Amendment Act. Okay, Article 334 Class 2 was added. This Constitution Amendment added women reservation in both the Lok Sabha as well as the assemblies. 1/3 reservation. Even the seats allocated to SC, ST also, out of them 1/3 seats will be allocated to women. We can see this as a extension of Panchayat Raj reservation. In Panchayat Raj, there is a 1/3 seats compulsory reservation to women according to Article 243D. Okay, this information you have to know, and we will see. Actually, this was not the first time the women reservation bill was introduced in the parliament. Previously, it was introduced, but various times it was lapsed. You know that when a bill either pending in the Lok Sabha or pending in Rajya Sabha, after it been passed in Lok Sabha also, if Lok Sabha dissolved, the bill will lapse. Okay, there are few conditions under which a bill will lapse. Because of that, bill lapsed previously. Now finally it got through the parliament. Now let's see notes regarding this. President given assent to the 128th Constitution Amendment Bill. So it became the 106th Constitution Amendment Act. 33% reservation to Assembly as well as Lok Sabha. How much percentage? 1/3 of the total seats will be reserved to women, and 1/3 of the seats of SC, ST also will be reserved to women, and this reservation will be valid to 15 years. After 15 years, it will be re-examined and it will be renewed if necessary. For the first time, it was this proposal was introduced in 1996, but it was lapsed due to the dissolution of Lok Sabha. It was introduced for the first time by Devegowda government, and the bill referred to the Joint Parliamentary Committee, which chaired by Geeta Mukherjee. The report submitted in 1996. Meanwhile, the Lok Sabha was dissolved, so the bill was lapsed. Such kind of situations were happened in 1998, 1999, in 2000. Actually, in 2008, for a difference, in 2008, the bill got introduced in Rajya Sabha. You know that if a bill is introduced in Rajya Sabha, and pending in Rajya Sabha, even though the Lok Sabha is dissolved, the bill will not lapse. Okay, because of that, the bill was not lapsed. But after Rajya Sabha passed the bill, when it entered into the Lok Sabha, when it was pending in Lok Sabha got dissolved. So bill was lapsed. Okay, and finally this time Lok Sabha and Rajya Sabha were successfully able to pass the bill, so that we are able to see the 106th Constitution Amendment Act. Regarding the women reservation in the legislative bodies, look at here. Gujarat, it elected only 8% of women legislator in its 182 member legislative assembly. Himachal Pradesh, for every 2 person, 1 is women. Even though such kind of population is there, so Himachal Pradesh assembly representing only 1 woman out of the 68, 67 are the men. National average, the national average of women in all the assemblies, they are around 8%. In spite, their population is around 50%. When you compare India at global level, India ranked around 144 out of the 193 countries in terms of women representation, and its rank is well below our neighborhood nations such as Bangladesh, Pakistan and Nepal. So this is about the women reservation bill. The second topic, this is regarding the election commission. You know that students, recently today itself parliament passed bill related to CEC as well as EC. So far there was no appointment committee regarding the CEC and EC. For the first time, parliament made an act. According to that act, Prime Minister and a minister nominated by Prime Minister plus leader of opposition is going to be the appointment committee. So, and this is the appointment committee according to this new act. And not only that, even previously in the previous bill, the service conditions, salary and allowances, they were similar to cabinet secretary. CEC and EC salary and allowances are similar to cabinet secretary, but now they changed again, they changed back to Supreme Court judge, so that their salaries and allowances cannot be changed. And even according to the new act, CEC and EC, whatever the functions they performed as a part of their duty, for those actions they won't be subjected to any civil or criminal cases. Okay, that is also you have to understand. That means they'll get immunity from civil as well as criminal laws as a part of their duty. Now the CEC and EC upon this services and terms of office bill 2023, it was passed today itself. Controversial provision, main controversial provision was their salaries and allowances. Previously they referred equal to cabinet secretary, but now they amended the bill and they made the salary and allowances equal to Supreme Court judge. Okay. And the appointment committee, actually regarding the appointment committee also, Supreme Court suggested that CJI should be in the appointment committee, but Government of India did not follow that advice in the bill. So instead of CJI, the cabinet minister nominated by Prime Minister was mentioned. And one more thing you have to understand here, the decision of this committee will be taken according to the majority vote. That means even though the leader of opposition is not present, the committee will go ahead with the Prime Minister and Minister, and they will go ahead with the appointment of CEC and EC. So according to this act, both the CEC and EC, they will get legal immunity in terms of both the civil as well as the criminal proceedings in relation to whatever the actions performed by them as a part of their official duty. Regarding the Election Commission of India, Election Commission of India established on 25th January 1950. On that day, we are observing National Voters Day, and Election Commission is expected to be independent body as well as it is a constitutional body. According to Article 324, Election Commission of India conduct election to President election, Vice President election, Lok Sabha, Rajya Sabha, Assembly and Council elections. Next, the Constitution also provided a separate election mechanism, election commission to state level, that is local bodies, that is in the form of State Election Commission under Article 243K. Next, some of the other related constitutional provisions. Part 15 of the Indian Constitution, it deals with the election and it establishes the Election Commission for the election matters. So the Election Commission was established in according to the Constitution on 25th January 1950. In Part 15 from Article 324 to Article 329, it deals with all the matters related to Election Commission and voting age, voting rights, voter list and everything. Yeah. So these are from Article 324 to 329. In this, the most important article is 324, Election Commission of India, 326, Universal Adult Franchise, 325, Preparation of Voter List by the Election Commission of India. Okay. The tenure of Chief Election Commissioners, tenure is, CEC tenure is 6 years. 6 years are 6 years regarding the CEC as well as EC. Salary already we discussed, equal to Supreme Court judge. Qualification, Constitution did not mention any qualification, even this proposed act also did not mention any qualification. They will be removed similar to Supreme Court judge. CEC will be removed similar to Supreme Court judge. That means special majority plus more than 50% of the house members, okay, have to accept in both the houses. Whereas the EC members can be removed on the recommendation of CEC. Next, composition of Election Commission of India. Originally, Constitution did not prescribe any composition. Originally, it was a single member body. In 1989, it became the 3-member body, and in 1990, it reverted back to single member body, and again during the PV Narasimha Rao government time, this Election Commission of India became the multi-member body, that is 1 plus 2, CEC plus EC. From then onwards, we are continuing the Election Commission of India with 1 plus 2 composition. Next topic, powers of governor. You know that students, nowadays governor role becomes very controversial. Actually, Constitution expected the governor should play the facilitatory role between the center and state. Rather than that, because of some governor actions, they are becoming the roadblock between the center and state. Regarding this, we have to know some information regarding the governor. Already yesterday, Supreme Court observed that when a bill forwarded to governor has to take action as soon as possible. Okay, governor cannot reject the bill. Governor can return the bill, or governor can accept the bill, or in special condition governor can send the bill for the president recommendation. So governor cannot sit on the bill indefinite period of time. That means governor cannot enjoy the pocket veto. That was a Supreme Court observation. Now we will see some basic information regarding the governor. Governor must be citizen of India and the minimum age 35 years of age, and he should not be member of any house. Next, appointment. Governor will be appointed by President of India for a tenure of 5 years, but governor will continue in his position on the pleasure of the president. And Governor can give resignation letter to president. During the emergency time, governor don't possess any additional powers. All the state executive powers are exercised by the president and legislative powers will be exercised by the parliament. Executive. Regarding the executive, all the state executive functions are vested with the governor. Governor will exercise those powers on the aid and advice of the Council of Ministers, and only in few conditions governor can exercise the discretionary powers. And all the executive matters in the state, they are on the name of the governor. And chief minister has obligations to update about state executive administration related issues to governor on regular basis. So this is the governor role in the executive. And in the legislative part, governor is a part of the state legislature, and governor assent is required for bill becoming an act, and governor summon the houses and prorogue the houses. Okay, so these kind of provisions are related to governor. And of course, governor disqualify the members as well on the recommendation of Election Commission of India. So power, the Supreme Court said that the real power is not vested with the governor, but it is vested with the elected government. That means a democratically elected government. So governor cannot sit on the bill indefinite period of time. Appointment of the governor, already we discussed. Okay, Article 154 Clause 1, governor executive power, he will exercise on the aid and advice of the Council of Ministers. In Shamsher Singh versus State of Punjab, here Supreme Court clearly mentioned that governor works as both constitutional head as well as the executive power of the state is exercised by only Council of Ministers. That means governor is only nominal head unless until discretionary powers are demanded, the situations demanded. When B.R. Ambedkar also clarified that the governor under the constitution, governor don't performs any functions at all, no functions at all. He was very affirmative regarding the governor role. Sarkaria Commission also mentioned that governor cannot go for any discretionary powers as long as the incumbent government is enjoying the majority in the house. Okay. Next, options before the governor when a bill come to the governor. So governor normally he has to assent the bill and he can withhold, okay, reject the bill, he can return the bill, and he can reserve the bill for the president consideration. But recently Supreme Court mentioned that governor cannot reject the bill also. As soon as governor has to return the bill, and if the same bill forwarded to governor again, then governor has to accept. When a bill referred to the president recommendation, then president can return the bill if it is not money bill, and president can reject the bill, and there is no time limit that president has to return the bill within this particular time. So that means president can exercise the veto power, pocket veto power with respect to state bill, And during the financial emergency, president may direct the state legislature that after they pass any financial bill or money bill, they must be referred for the recommendation of the president. Okay. Next, governor cannot go for the no action. Like I said earlier, governor has to take any action according to Article 200. That is what Constitution expected. These are the takeaways. Governor has to take an action as soon as possible when a bill reaches to the governor. Governor cannot sit on a bill perpetually. So Justice BP Jeevan Reddy Committee, it suggested that the governor withholding to the assent indefinitely, it will not be conducive to the democracy, and it is not conducive to the decorum of governor office, and governor should not delay the bill. And National Commission to Review the Working of the Constitution 2000, it suggested there must be a timeline regarding governor approval to bill. Within that timeline, governor has to approve the bill, or else governor has to express his opinion regarding the bill. Okay. And even some commission recommended there must be a removal process to the governor as well. That means governor should be able to removed by the state legislature. That must be there. Next, discussion on the simultaneous election parliament. Recently, in parliament special session, they appointed one committee to check the whether simultaneous elections can be possible or not. Okay, possibility of simultaneous election. Simultaneous elections is all about conducting elections simultaneously for assembly as well as the Lok Sabha. Okay, it can be in a single phase or it can be in two phases. That means for every 5 years, elections will be held twice. In one time, half of the states plus UTs and Lok Sabha elections will happen. After 2.5 years, rest of the states will go to the election. That means within 5 years of tenure, 2 times elections will be happened. That is one method. The second method will be for every 5 years, all the assembly elections and Lok Sabha elections will be held. That is one more method. Of course, now it is not feasible because for that lot of constitution amendments required. So far those amendments were not done. So in 2024 Lok Sabha elections, you cannot expect the simultaneous elections. Why it is in news? The government constituted a committee. This committee is headed by Ramnath Kovind. They are going to explore the concept of one nation, one election. This was discussed in the special parliament session. It was happened between the September 18 to September 22. Simultaneous elections means synchronized election to both Lok Sabha as well as the state assemblies. If you look at here, the highlights of the issue, why the simultaneous elections are required. If you look at here, between 2014 to 2022, almost all 50 state legislative assemblies elections were happened. When elections are happening at any point of time, at any different places in the country, every time whenever the elections are happening, model code of conduct will be imposed. So that is affecting the policy continuity. That is the main issue. And whenever as the elections frequency are very high, the political parties and governments are always in the election mood. So there are chances that they will neglect the actual administrative issues. Expenditure normally, if elections happen to only assembly, the entire expenditure will be the state. If the elections happen to only Lok Sabha, the entire expenditure by the center. If elections conducted in the state for both assembly and Lok Sabha simultaneously, for example state like Andhra Pradesh, there the expenditure has to be shared by both center and state with 50 and 50%. Regarding simultaneous elections was there till 1967. After that, as the states are getting dissolved before 5 years, the simultaneous elections, the tradition got broken. Election Commission annual report in 1983 supported the simultaneous election. Law Commission report in 1999 and Niti Aayog reports on the subject in 2017 and Law Commission 2018. These are the various reports suggested the simultaneous elections in India. Next, how it will work. Already mentioned, it will work by amending various key provisions in the Representation of People Act, and there are two possibilities. Those two possibilities already I explained to you. So the supporting arguments for simultaneous elections, it reduce the policy paralysis, reduce the huge expenditure on elections, disruption of public life in the name of model code of conduct. It also reduce the impact on the social fabric, because during the election time, political party criticize on caste line, on religious line, that can also be reduced if we have only uniform elections, and reduce the impact of populist measures and increase the voter turnout. If election frequency is reduced, then obviously voter turnout can be increased. Okay, there is a possibility. Challenges: first we have to amend the constitutional provisions, and almost all half of the state assemblies they have to ratify these changes. Following articles subjected to amendment: Article 83, Article 85, Article 172 and Article 174 and Article 356. These are the articles subjected to constitution amendment. Then apart from that, the other challenges are voters. If elections are happening to center and state simultaneously, voters' judgment, the judgment regarding the state issues, that will be covered by national issues only. That means state issues will be overtaken by the national issues, so that state governments will not be elected based on the state issues, they will be elected based on the national issues. So it affects the judgment of the voters. Reduce the accountability of government, because once you are elected, you will be there for 5 years. So no matter whatever the work you do, so it reduces the government accountability. And logistical issues, because it requires a lot of manpower as well as EVM machines. That is one of the issue. Law Commission of India. So here couple of times we got the Law Commission mentioned in this PPT. Law Commission is an executive body, it is an advisory body. Whatever the advices given by the Law Commission are only binding, and it consists of legal expert. First Law Commission of India in 1955. If you remember, tell me students, first Law Commission during the Britishers' time, it was led by whom? Who led the first Law Commission during the Britishers' time? Indian first Law Commission was headed by MC Setalvad. Whatever the advices given by them, they are not binding. And Law Commission members, there are legal and judicial experts, ex officio members. Law Secretary will be the ex officio member, and Secretary to Legislative, that means Lok Sabha, Rajya Sabha secretaries and Law Ministry secretaries, they are going to be the ex officio members in this Law Commission. Law Commission history. For the first time, Law Commission was appointed according to Charter Act 1833, that was in 1834, under the chairman of Macaulay. That Law Commission was dealt with codification of laws, which resulted to codification of Indian Penal Code. And Law Commission functions. So they studied the present laws, and if any future recommendations are there, they suggest the recommendations. Not only that, they also study how the laws are affecting the poor and how the laws can be more inclusive in nature. Okay. Next, Article 35A and Article 370. Recently, Supreme Court upheld the cancellation of Article 370, and Supreme Court clearly mentioned that Article 370 also subjected to Article 1. What is Article 1 is saying? Article 1 is saying that India is a union of states. That means even though Article 370 is giving certain autonomy to the Jammu Kashmir, that autonomy is only temporary provision. It is not the permanent autonomy. And Jammu Kashmir is subjected to Article 1. That means Parliament can make laws, any laws related to Jammu Kashmir. We will discuss what is this Article 370 adding to Jammu Kashmir, what kind of provisions it is adding, and what is this Article 35A in the Jammu Kashmir Constitution. We will try to understand. Okay. Supreme Court Constitutional Bench, it upheld the validity of government order regarding the cancellation of Article 370. Okay. The court held that Article 370 is a temporary provision. It is not having any, it is not part of the sovereignty, not part of the sovereignty of India. The reorganization of Ladakh as well as Jammu Kashmir, it is also valid under Article 3. So these are the observations of Supreme Court. Article 370 mentioned in the Indian Constitution under part 21 as a temporary, transitional and special provisions. Article 370 given special rights to Jammu Kashmir people. Okay. Since 1954, in accordance with the Instrument of Accession. Instrument of Accession was an agreement between the Raja Hari Singh as well as Government of India during the 1948. Okay. In 1948, there was an agreement happened between these two, so that Government of India offered help to Jammu Kashmir Kingdom when they were fighting against the Pakistan provoked war. It was temporary in nature. And features of Article 370. Article 370 provided special separate constitution to Jammu Kashmir, separate citizenship, and parliament laws cannot be applicable in Jammu Kashmir except in the condition of defense, foreign affairs, finance and communication. They can have their own flag, and their assembly can have 6 years of duration, and reservations also they can decide their own. And according to this Article 370, they have their own constitution. Yeah, in their constitution they have the provision of Article 35A also. The 35A, it was issued as a presidential order in 1954 after an agreement was made in 1952 between then Prime Minister Jawaharlal Nehru and Sheikh Abdullah. This presidential order was included under Article 370, Clause 1, Subclause D. This Article 35A provided special rights to Jammu Kashmir people. They are the Jammu Kashmir permanent residents. They can only permanently reside in the Jammu Kashmir. They only can buy the land. They can only held the local government jobs, and they are only the eligible for the government scholarships in education, school and other institutions. And if female resident of Jammu Kashmir, if they are married to any person outside of the Jammu Kashmir, obviously they lose all their property rights from their parents. So this kind of discriminatory things are there. Because of that, Article 35A faced a lot of criticism, and Article 35A was not added according to the Constitution Amendment, that is not according to the Parliament law. It was simply added by President order. That is also not a right way according to some of the critics. So these are the top 5 topics of today's video. Now let's see yesterday's video question. The term Ind Arc, sometimes seen in news, is the name of what? India's 2019 underwater observatory to scientifically study the Arctic region. It is related to Arctic region. In yesterday's video we discussed about the Arctic winter expedition for the first one. Now today's question, consider the following and choose the correct code. Out of these 4, which one is the right statement? Now, next question. Under which article of the Indian Constitution the governor has power to reserve bill for the president assent? Next question. Which statement is not correct about Jammu and Kashmir? Okay, read the 4 statements and which one is not correct. Okay, these are today's MCQ questions, and as we reach to the end of this video, as a part of Prelims High Yielding Series 1 in Polity, we discussed about following 5 topics. Give your feedback so that I'll try to include as many topics as possible. And this is the detailed analysis regarding these 5 topics. Thank you.